there's any threats to the judiciary, that we can then, in early notice, stand up and protect the judiciary. Because the judiciary is absolutely important for the functioning of a constitutional democracy. It's the only branch of government that would check on the other branches if there's excesses that they are conducting themselves with, and bring them back into what the Constitution requires. So it's absolutely important that we make sure that the judiciary is protected at all costs.
Yes. Perhaps let's talk about today's proceeding. What should members of the public harbor? What should be the expectation? What is most likely to come out today from, perhaps, maybe let's start with the speech of the Chief Justice. Do you also personally have some expectation that some certain issues will actually be ventilated or articulated today?
I think generally the Chief Justice is likely to give some statistics as to what the performance of the courts were from the Supreme Court, High Court, and the Magistracy. How many cases had been dealt with, how many judges were appointed or set on these sort of cases, and what the rate of disposing of these cases, finalizing, bring them to finalization. That would be what the Chief Justice normally will do at occasions like this, and I don't expect any different this occasion around. But it's also important that the Chief Justice will say, well, what are the resources that he would require in order to effectively administer the judiciary for the next immediate and long-term plans of the courts. So those statistics, I'm sure the Chief Justice will narrate to the public.
Yes. Ms. Shaikika?
Well, in addition to what Norman has indicated, I also believe that in mapping out the plan for the year, thus setting the tone for the judiciary, from which institutions like the Law Society would be able to know and see in what way do we then support, as a stakeholder, the judiciary in ensuring that it does actually realize the plans that it has set for the year. Because you would know that as the Law Society, we regulate the legal fraternity that are officers of the court, and thereby assisting the court in its achievements. As Norman said, that we would expect the statistics in terms of the successes of the court in the past. So there would be a contribution without any doubt that the legal practitioners have played in ensuring those successes by the court. So those are just some of the things that we would be expecting to hear from the Chief Justice.
Yes, thank you. Mr. Shombe, as a legal practitioner, have you noted any significant development over the past year, and perhaps some challenges? Of course, I would also want to hear that from the perspective of the Law Society.
Well, significant developments in the past year. One is that we had the highest number of female judges appointed, although on an acting basis, to the Supreme Court. That's quite significant, because that obviously sets the tone that the transformation in terms of gender must also happen at the highest court. And the Chief Justice has obviously taken the lead with that to make sure that we have female judges also sitting on a bench. So we had on one occasion, and I'm sure we will have more of those, that the bench was just, in one particular case, constituted of female judges, which has never happened in the history of the country. But the fact that it has never happened, that's a challenge, that we do not promote enough female legal practitioners to the bench, and we should be doing that. We should consciously and deliberately make sure that we have female legal practitioners aspiring to become judges at the High Court and obviously the Supreme Court ultimately. And we need to work towards that. We need to investigate the reasons why we don't have enough female judges, why are female legal practitioners, where judges are naturally selected from, not willing or able or available to serve on the bench. And those are the challenges. So whilst we're celebrating the fact that we have had the highest number of female judges ever appointed to the Supreme Court, we must also then say, why only now? What are the obstacles?
Yes.
And we need to investigate it and address it if there are those sort of problems that are there.
So that the future is basically sorted out.
Yes, indeed, so
Yeah.
that we have more equality and equity.
Yes. On your part, perhaps.
Okay, apart from the Supreme Court, 3 female judges that we also as the Law Society have celebrated, I also want to mention that the Supreme Court has now also set the tone in terms of the processes that are embarked upon in the appointment of judges. We now know that there is publicized, widely televised through NBC TV, the processes where the judges would be interviewed, for instance. So that is a development that should be welcomed, because that way then, as the stakeholders and as the nation, we are able to take part and see that process that is involved in the appointment of the judiciaries. So that is one part, and also that's the process that led to 2 female judges being appointed at the High Court as well. So that is a development that should be welcomed. And also, perhaps if there is a need, also one would just add to say perhaps that's one of the areas that we need to look at, as Norman correctly pointed. There may be a shortage of judges, and specifically talking about female judges. Perhaps there is a need for the stakeholders to come together so that also as a law society we play a role in encouraging our female members to partake in the appointment or in being appointed as judges of the High Court.
Yes.
So that would be a role that we would be interested in playing as a support to the judiciary.
Yes, I think I, from my side, have noted in terms of transparency, we've seen that for the first time the appointment of judges was basically done in the public knowledge. The interviews were actually conducted in public. Maybe just what you have to say about that, Mr. Shombe.
Well, it's absolutely a very important issue. It has been a matter that has been the talk of the town, that judges are not appointed in a transparent manner. People would ask, whispering and asking, why is that person appointed and not that person? And some of us don't know the answers, but I mean, if you don't do things in the open, people will always have questions. If you do it openly then, and transparently, then obviously some of the questions, most of the questions will be answered immediately without further ado. But it's important for many other things also, is that, as I said earlier, the judiciary, like all branches of government, serve the public. And it's that very public that must look at and see who are appointed in their name, what is being done in their name, but also that, you know, the performance of judges is absolutely important. It's the most important aspect of the judiciary. It's like, is a judge competent? Remember, the Constitution guarantees you a competent court or tribunal. And that competency in various ways, not just technical legal aspects, but also whether, you know, a judge understands the society that he or she would operate in order to dispense justice in a fair and equitable way. So the public would then be able to judge and say, this person, through whatever measures that we implement in order to solicit the performance of a judge with interviews and written tests and the like, the public can then also see that this person is not competent enough to do that. To be able to be a judge, or that person is in fact the competent person to be appointed. But also it then eliminates things like, you know, inappropriate appointments where someone is appointed as a judge because he's friends or with so-and-so, and therefore he must be appointed. All of those things are eliminated to a large extent. I mean, you won't be able to remove all sort of obstacles, but it is absolutely a very, very good step in the right direction to make the recruitment of judges
Yes.
in a public and transparent manner.
Yes, I think from the onset we spoke about when the late President Hage Geingob would officiate an event like this, and where he would give an assurance to say the judiciary will be respected, systems, institutions and processes will take course and so on. Today we actually witness for the first time the opening of a legal year by Dr. Nangolo Mbumba. Any expectation from your side?
Well, what we expect would be that he will carry on the legacy, that he will.
Yes, you will have to hold your thoughts there. I think we need to cross over to the main event. I think I see that the Chief Justice just walked in. Let's just follow the proceedings for now.
Thank you very much. Good morning. May you have the anthems, please? Much. We may be seated. His Excellency Dr. Nangolo Mbumba, President of the Republic of Namibia, His Lordship the Chief Justice, good morning to you all and most welcome to the Supreme Court for the launch of the 2024 legal year. May we just switch off our phones, put them on silent mode, please. As has now become customary, my task is to direct proceedings efficiently and seamlessly as far as is humanly possible. First, I will establish today's order of protocol. The purpose of doing so is to remove the burden from our keynote speakers of having to recite the protocol and allow us to make a mistake in the process. If anyone is excluded, I accept full responsibility. So I announce today's order of protocol. His Excellency, the President of the Republic, and His Lordship, the Chief Justice, Your Worship, the Acting Chief Magistrate, Honorable Speaker of the National Assembly, the Honorable Chairperson of the National Council, the Honorable Minister of Justice, the learned Attorney General, the Honorable Judges of the Supreme Court, Honorable Judges of the High Court and retired Judges of the High Court, the learned Ombudsman, Honorable Ministers, and in particular, I would wish to recognize the presence of the Minister in the Presidency, given the special nature of this occasion, the Director General of the National Planning Commission, the Honorable Governor of the Commerce Region, the Honorable Governor of the Bank of Namibia, Your Worship, the Mayor of the City of Windhoek, the Executive Director of the Office of the Judiciary, and all other Executive Directors present. Also our retired Executive Director, thank you for coming to join us, the Chairperson of the Public Service Commission and its members, Chief of the Law Reform and Development Commission, Commissioner General of the Namibian Correctional Service, Inspector General of the Namibian Police, Chief of the Windhoek City Police, their worships, divisional, regional, and district magistrates, the learned President of the Law Society, the learned Director of the Law Society, the learned President of the Society of Advocates, the learned person of the Namibia Law, Chairperson of the Namibia Law Association, all esteemed members of the Law Society of Namibia, staff of the Office of the Judiciary, media representatives, all invited guests, ladies and gentlemen, you are all recognized. Now that the order of protocol has been established, allow me, because of the backdrop against which this year's legal year takes place, to make very brief but important observations. Your Excellency, Your Lordship, the Chief Justice, in the early hours of the morning of 4 February, the third President of our Republic passed away, and at a time that the Namibian nation was looking up to him to guide us through elections and a peaceful transfer of power to a new administration. On the same day, in the afternoon, the Chief Justice presided over a peaceful and orderly change of guard to the fourth President of our Republic, our guest of honor at this auspicious occasion. Congratulations, Your Excellency. In the aftermath of the passing of our departed President, not a single shot was fired in our streets. There was no violent protest, disturbance, or insurrection. There was no attempt at a power grab. There was no brawl and throwing of chairs in Parliament. Namibia's democracy had indeed come full circle. Thanks to what our now fallen head of state often referred to as a sound democracy and governance architecture, he was so instrumental in not only creating but also nurturing. As we mourn our departed head of state, it is opportune that we recall his commitment to the independence of the judiciary, as will be more fully done by the Chief Justice. In his 2023 address, he said from this podium, "The judiciary is constitutionally mandated to oversee the critical function of the administration of justice, which is an integral component of our governance architecture. As one of the architects of our constitutional democracy, I am an ardent promoter of the independence of the judiciary. Therefore, let me once again reaffirm the executive's promise to upholding the rule of law and pledge that the judiciary will continue to enjoy unfettered independence. the sacrosanctity of judicial independence in Namibia can never be questioned. It has been suggested by some, and please accept my bona fide disclaimer, that I have no evidence to either confirm or disprove the claim that it is a fool's errand to find a more unambiguous and authentic assertion by a head of state outside Namibia on the independence of the judiciary. These were not mellifluous platitudes intended to placate critics. Working alongside the Chief Justice in his interaction with the executive, I experienced how the head of state lived through to that commitment. Long may his legacy live. Those are the brief, important observations I wanted to make. Your Excellency, ladies and gentlemen, before I call the Chief Justice, I would invite the choir to give us an item. The Judiciary Choir. much, the Judiciary Choir, for that very moving performance. It is now my distinct honor to invite His Lordship, the Chief Justice of the Republic of Namibia, to give us his address on the state of the judiciary. Chief Justice.
Your Excellency, Dr. Nangolo Mbumba, President of the Republic of Namibia, our Director of Ceremonies, the Honorable Pietrus Damaseb, Deputy Chief Justice, I worship the Acting Chief Magistrate, the Honorable Speaker of the National Assembly, the Honorable Chairperson of the National Council, the Honorable Judges of the Supreme Court and of the High Court, the Honorable, their worships, divisional, regional, and district magistrates, Honorable Ministers, Honorable Deputy Ministers, all my distinguished invited guests here present, ladies and gentlemen, we gather today at the Supreme Court under somber circumstances. On the 4th of February 2024, our nation was struck by a profound loss. His Excellency Dr. Hage Gottfried Geingob, the President of the Republic of Namibia, passed on. As we inaugurate the opening of the 2024 legal year, we do so with heavy hearts, aware that our nation has lost not just a leader, but an icon and a stalwart of our liberation struggle, a remarkable leader and compassionate statesman. Today's event, marking a decade of this revered tradition, is not just about the commencement of a new judicial calendar, but also a moment to reflect on President Geingob's immutable legacy, visionary leadership, and tireless dedication to public service, forever engraved in the annals of Namibia's history. The absence of President Geingob is profoundly felt today at an event which he graced without fail since its inception in 2015. His unwavering commitment to this occasion signified more than just his presence. It symbolized the executive's recognition and support of the judiciary as an independent yet integral organ of the state. Today, as we reaffirm our dedication to the principles of justice and integrity, which are the bedrock of our judiciary, we also honor his memory and the legacy that he leaves behind. A legacy of unwavering commitment to the rule of law, separation of powers, and constitutionalism. These are the ideals that will continue to inspire us as we commit to a fair dispensation of justice in our nation. On my own behalf, and on behalf of the members of the judiciary and the support staff, I extend my deepest condolences to Madam Monica Geingos, the children, and the rest of the beloved family. In the words of the late Nelson Mandela, former President of the Republic of South Africa, I quote, "Death is something inevitable. When a man has done what he considers to be his duty to his people and his country, he can rest in peace." Indeed, His Excellency President Geingob did his duty to his people and his country in an exemplary fashion, May his soul rest in eternal peace. With Your Excellency's indulgence, may I now invite all of us, and this includes also the members of the judiciary and the support staff who are watching or listening in across the width and breadth of our country, as previously directed, to rise to observe a minute of silence in respect of the memory of our dear departed president. Thank you. You may be seated. I'm deeply grateful for the presence of our guest of honor, His Excellency Dr. Nangolo, President of the Republic of Namibia, and senior members of his executive, especially under these challenging circumstances. I'm equally grateful for the presence of Honorable Professor Peter Kashavevi, the Speaker of the National Assembly, Honorable Lucas Nimbo Muha, the Chairperson of the National Council, and the distinguished members of the legislature. I also extend my greetings to the members of the legal fraternity present here today. Your consistent presence at these events, now under these solemn circumstances, is deeply valued. It reflects your commitment and genuine interest in the welfare and activities of the judiciary. Your Excellency, 2023 was yet another eventful year, full of significant firsts for our jurisdiction. I do not intend to keep you long with my address, but I want to highlight important events and noteworthy statistics that are relevant to the performance of the individual courts and the judiciary as a whole. The comprehensive statistics detailing the performance of the courts will be accessible on the Superior Court's website, which is ejustice.jud.na. But starting with the Supreme Court, last year, the court took a significant step in fulfilling its commitment to enhancing diversity on the bench. The appointment of 3 women, namely Lady Justice Hanneli Prinsloo and Lady Justice Esishiming Chase, both judges of our High Court, along with Lady Justice Rita Makarao, a judge from the Constitutional Court of Zimbabwe, as acting judges of the Supreme Court, heralded in a new era. This historic development not only demonstrates our resolve to bring more female representation to the Supreme Court, but also enriches the range and depth of judicial insight at the summit of our legal system. The Supreme Court also made commendable strides in expanding its capacity to hear more cases. By operating 2 courtrooms concurrently during each term, the court has successfully increased the number of cases set down for hearing, thereby significantly reducing its backlog of cases. Between the 1st of January 2023 and the 21st December 2023, the Supreme Court encountered a marked increase in its caseload, witnessing a surge in the number of appeals by approximately 59% compared to the previous year. Despite this rising trend and the heightened demand for judicial services in recent years, the court has successfully managed to uphold its high standards in the disposal rate of cases. This is apparent from the fact that the court has not only heard but also effectively resolved a significant portion of these cases. Specifically, from the start of 2023 until late December, out of 98 matters that were enrolled, 93 were heard and judgments were delivered in 87 of these, translating to a caseload or case disposal rate of 93.5%. In recent years, a concerning pattern has taken root and persists, where some litigants, and more concerningly, legal practitioners, exhibiting a recurring disregard for the court rules. This ongoing trend has frequently resulted in the dismissal or removal of cases from the roll, leading to apprehensions regarding the inefficient utilization of the court's valuable time and resources. It is crucial that both litigants and especially legal practitioners make a concerted effort to familiarize themselves thoroughly with the court's rules to uphold the efficiency and integrity of our judicial process. Moving on to the High Court, in 2023, the High Court comprised 17 permanent judges and 5 acting judges, including 1 ad hoc judge assigned to a specific case. The High Court main division and the civil stream demonstrated a notable efficiency in case disposal rate, finalizing a total of 6,827 civil and labor cases, which accounted for 64% of the matters heard during the year. Notably, 5,355 of these cases met the prescribed disposal benchmarks, leading to an impressive on-time disposal rate of 78%. This achievement underscores a pattern of steady improvement in the on-time performance of the main division. When we look back at the previous years, we see a clear trajectory of progress. In the 2022 legal year, the main division handled 7,018 civil and labor cases with an on-time disposal rate of 73%. This was a significant increase from the 2021 legal year, which saw a total of 9,828 cases with an on-time disposal rate of 71%. The consistent upward trend in performance is evident when comparing these figures with the 2022 legal year, during which time the High Court processed 9,893 cases and achieved an on-time disposal rate of 72%. The judicial case management system remains a cornerstone in this success, ensuring efficient case handling and timely resolution of disputes. As we move forward, the High Court's commitment to improving its case management and disposal processes remains steadfast, reflecting our dedication to upholding justice and serving the needs of our community effectively. Regarding the handling of criminal cases in the High Court main division, the court achieved a disposal rate of 28% for indictments. Nevertheless, the stream demonstrated a higher efficiency in other areas, accomplishing a 90% disposal rate for criminal appeals and an 83% rate for reviewing cases from the lower courts. One of the measures implemented in 2023 to tackle the challenge of delayed court proceedings was the revival of circuit courts. This initiative was carried out in the Zambezi, Kavango East, and Kavango West regions, with the judge president presiding over the cases. The 2023 circuit courts proved a monumental success, and the High Court intends to institutionalize circuit courts as a regular practice. In alignment with the judiciary's commitment to the principles of transparency and accountability, the Judicial Service Commission took a significant step in this regard towards the end of last year. The Commission resolved to amend the Judicial Service Commission regulations to mandate that interviews of nominated candidates for judicial offices be conducted in public, marking a pivotal change in our appointment process. In November of last year, the first public interviews were held and resulted in the subsequent appointments of Judge Philanda Christian as a substantive judge of the High Court, following her previous role as the Chief Magistrate and an acting judge of the High Court, and Advocate Beatrix de Jager as an acting judge of the High Court. Although the selection of judicial officers has consistently been transparent, the move to conduct interviews publicly, as stipulated by the newly amended regulations, reinforces our commitment to an open and accountable judicial system. Turning now to the lower courts, in the year 2023 legal year, or in the 2023 legal year, the lower courts witnessed a dynamic period of change and development. 2 divisional magistrates were elevated to the position of judges, reflecting a significant step in their judicial careers. Moreover, key promotions within the ranks included the advancement of a principal magistrate to deputy chief magistrate overseeing court administration, the elevation of 2 principal magistrates to divisional magistrates roles in Rundu and Oshuarongo, and the promotion of a principal magistrate to a regional court magistrate position. Additionally, the upward movement of 3 senior magistrates to principal positions and the promotion of an entry-level magistrate to a senior role underscores the judiciary's focus on recognizing and rewarding judicial competence and dedication. The recruitment drive brought in 11 new magistrates, enhancing the operational capacity of our lower courts. However, the judiciary also faced challenges with 7 resignations spanning various levels of the magistracy, coupled with the retirement of a deputy magistrate, or a deputy chief magistrate rather, and a principal magistrate. The year was also marked by notable administrative advancements. The declaration of new seats of courts in Okahao, Ohangwena, Gohas, Stamprit, Vetflay, and Impalila Island represents a crucial expansion in our judicial reach, ensuring great access to justice for our citizens. Moreover, the increment in the remuneration of magistrates is a step towards acknowledging their invaluable contribution to the judiciary. While the lower courts made significant strides in judicial appointments and administrative enhancements, the achievement of set targets was constrained by insufficient budgetary provision, a challenge that underscores the need for adequate support to ensure the efficient functioning and further development of this critical sector of our judiciary. In 2023, the regional and district courts handled 4,682 additional cases compared to the year 2022. Despite this surge in caseload, the lower courts accomplished 37% case disposal rate in 2023, marking a 5% increase from 32 disposal rate achieved in 2023. Clearly, a lot remains to be done in that regard, and we have a plan for that. Over the past year, the Magistrates Courts Act 32 of 1944 underwent a crucial amendment through the promulgation of the Magistrates Courts Amendment Act, Act 18 of 2023, marking a significant progress in the protection of the most vulnerable members of society. This legislative change introduces a clearer definition of a primary home, emphasizing the need to protect one's principal residence from arbitrary sale in execution. The amendment empowers the Rules Board to craft guidelines for sales in execution of immovable property, ensuring these transactions are conducted equitably and in line with the property's actual value. Additionally, the amendment notably expands the jurisdiction of magistrates' courts. This expansion enables these courts to handle a broader spectrum of cases, thereby enhancing access to justice, particularly for individuals in remote or underserved regions. The new provisions also introduce safeguards against the sale in execution of immovable property, especially when it concerns an individual's primary home, aligning with our ongoing commitment to safety or safeguard property rights and to uphold human dignity. This change in legislation reflects the adaptability and responsiveness of our judicial system and our country in general to the evolving needs of our society. The President's approval of this amendment signifies government's and the judiciary's joint commitment to refining the legal framework governing property rights and debt recovery in harmony with the principles of fairness, transparency, and respect for the rule of law. The budget of the Office of the Judiciary is a crucial aspect of our ability to execute our mandate effectively. The revised budget ceiling received in the 2017-2018 financial year was well catered to the needs and operational needs of the judiciary. However, subsequent budget ceilings have been rather insufficient, leading to the carryover of unpaid outstanding invoices each year. The challenge faced in terms of budget allocation the Office of the Judiciary has continued to receive an unqualified audit reports, showcasing our commitment to good governance and financial accountability. Some people do not understand what unqualified audit reports are, because they say, if it's so good, how can it be unqualified? In the Auditor General's reports on the accounts of OMAs, offices, ministries, and agencies, an unqualified report is defined as meaning that, quote, the auditors conclude that the financial statements of the OMA present fairly its affairs in all material respects. I would like finally to deal with some aspects of capital projects and infrastructure for the courts. In our pursuit of justice and our commitment to providing accessible, efficient, and fair judicial services to all its citizens, the importance of increasing and maintaining our court infrastructure cannot be overstated. While our budget allocations have been challenging, the need for continued investment in capital projects remains paramount. In the 2017-2018 financial year, we received a budget allocation that allowed us to address some of our most pressing needs. However, subsequent years have highlighted the growing demand for modernized court facilities, advanced technology, and improved access to judicial services. The Office of the Judiciary recognizes the urgent need for capital projects that not only refurbish and expand existing court infrastructure, but also integrate advanced technologies to streamline case management and court proceedings. These projects are not just about constructing buildings, they are about building the future of our judiciary. As we advocate for increased budget allocations, we envision capital projects that encompass the development of new court facilities in underserved regions, the expansion of our electronic case management systems, and the enhancement of security measures to protect sensitive information and ensure the safety of our judicial staff and the public. These initiatives are critical in our journey towards a judiciary that is not only physically accessible, but also technologically adept and equipped to handle the challenges of the digital age. The successful implementation of these capital projects will require collaborative efforts and the support of all stakeholders. As I conclude, as we embark on the 2024 legal year, let us remain steadfast in our pursuit of justice, our commitment to upholding the rule of law, and our dedication to serving the people of Namibia with integrity and excellence. Together, we can overcome the challenges ahead and continue to strengthen the fabric of our judiciary, ensuring that justice is accessible, timely, and fair for all. I thank you.
Thank you very much, Chief Justice, for that very important address on the state of the judiciary. I now wish to invite the NCS brass band to render an item. Thank you very much, the NCS Brass Band. It is now my honor and privilege to invite His Excellency the President to give his address.
Please, let us take our seat. Your Lordship, Peter Shivute, Chief Justice, Honorable Deputy Chief Justice, Petrus Damaseb, Honorable Yvonne Dausab, Minister of Justice, Honorable Festus Mbandeka, Attorney General, Honorable Speaker, you were not considered that you'll be part of the speech. Thank you very much for joining us. Honorable Professor Dr. Peter Kachavivi, Speaker of the National Assembly, Honorable Sinimba Muha, Chairperson of the National Council. Before I get in trouble, the protocol has been already established. Let me abide by it. Good morning. I am pleased to join the esteemed members of the judiciary and the broader legal profession for the official opening of the 2024 legal year, which most regrettably is taking place at the backdrop of the sad passing of our beloved President of the Republic of Namibia, His Excellency Dr. Hage G. Geingob. Our country lost a towering, iconic, and heroic person, a true champion of the ideals of unity, peace, and justice for all. The minute of silence has already been observed. And I'm pleased that the judiciary has saw it fit that you will also contribute, you will also discuss, you will also pay your tribute to what Dr. Geingob has done for our country. Our late President, Dr. Geingob, named 2024 the year of expectations. Little did we know that some of these expectations will be tough to accept, and we did not even think that this was possible. This theme resonates with the important events taking place in our country this year. Among them, the presidential and National Assembly elections, where all Namibian citizens will exercise their constitutional rights and elect their leaders democratically. The judiciary, as an independent organ of state, should play its constitutional and complementary role to ensure the seamless holding of elections that are free and fair. The judiciary has a clear constitutional mandate to oversee the administration of justice and is therefore expected to do so independently, to do so impartially, to do so reasonably, and if possible, to do so speedily and with the required competence and integrity. The public also expects the judiciary to take into account the sacred principles of the rules of natural justice. This will instill public trust in the operations of the judiciary. Your Lord, the Chief Justice, ladies and gentlemen, the drafters of the Namibian Constitution were very clear on the need to entrench the doctrine of separation of powers in order to safeguard our democratic institutions and principles. This is a doctrine that we cherish, and as a president, I too will continue to reaffirm, as our late president did during his tenure, the doctrine of separation of powers and the safeguard of its continuous applications in practice. Moreover, it is important that we maintain a collaborative spirit between the executive, legislature, judiciary branches, whilst respecting their distinct constitutional mandate. This relationship is mutually supportive and must not be misconstrued as interference in this or that branch of government. It is therefore important that the courts, judges, and judiciary staff are able to perform their duties without unwarranted pressure or influence from any quarter of our society. Consequently, it is disheartening to observe that sometimes the judiciary is subjected to unjustifiable criticism for its decisions in the performance of its professional duties. Such criticism on judiciary officers could become a hindrance to the effective exercise of judiciary functions and the administration of justice. I therefore urge Namibians to desist from actions that could be tantamount to the interference with the work of the judiciary. The rule of law is essential in the preservation and advancement of our democracy, unity of nation, and socio-economic development. The rule of law is an important constitutional anchor of our democracy. It is a nexus that enhances social development using law as an instrument of change. Therefore lies the transformative function of the judiciary and the broader legal profession, albeit in two different roles. The judiciary plays an influential role as a custodian of our society's core values and the rule of law, and must therefore be led by men and women who hold themselves to the highest ethical standard of conduct. During this year of expectations, the judiciary and the broader legal fraternity are expected to carry out their functions with integrity and in the spirit of patriotism. I am reminded of what Chinua Achebe once said, and I quote, "One of the truest tests of integrity is its blunt refusal to be compromised," end of quote. It is therefore my hope that at these platforms and others, you will reflect on these issues deeply and protect the collective integrity of the profession and its associated processes, systems, and institutions. I acknowledge the fact that despite fiscal constraints, and the resultant budget cuts, the Office of the Judiciary has managed to achieve notable milestones during the 2022-2023 financial year. I therefore encourage members of the Judiciary to continue carrying out their work efficiently and effectively. The government will continue to support the Judiciary through providing budgetary funding to enhance its capacity. Such support is instrumental in the filling pivotal vacancies and advancing courts' physical and technological infrastructure, thereby improving judiciary efficiency, effectiveness, and service delivery. In conclusion, which is not really yet a conclusion, it is important that all three organs of state, the judiciary, executive, and legislature, share the correct understanding that their core value is to improve the lives of Namibian citizens on whose behalf they are exercising those authorities. The Namibian people are the sovereigns, and they have the power to judge our performance and decide whether they would want us to continue working with them and working on their behalf. Therefore, all of us in government, including judiciary, have to take this fact into account and ask ourselves critical questions such as, have we discharged our responsibility to the best of our ability, and have we improved the lives of our people? How do we dispense justice for all Namibians, or did we discharge justice for all Namibians? Is justice accessible, timely, and affordable to the citizen of this country? Where are the areas in which we ought to improve to satisfy the citizens, the sovereign? This is a crucial year, and therefore we cannot have a business-as-usual approach. I urge every member of the judiciary and the legal fraternity at large to ensure that justice reaches all Namibians and that the judiciary contributes tirelessly to our collective welfare and the betterment of Namibia, living up to the expectation of our citizens. I now wish you all the very best. Although the beginning was tough, hopefully the rest of the year will be better. I hereby declare the 2024 legal year officially open, and I thank you for your kind attention.
Thank you very much. Your Excellency, regrettably, in the way the program is organized, the Chief Justice does not have a right of reply. So on his behalf, and on behalf of the Judiciary and the entire legal fraternity, I wish to sincerely thank you for such an unambiguous and equivocal statement towards the commitment to the independence of the judiciary, the separation of powers, which you have so clearly articulated on behalf of the fourth administration for the Republic of Namibia. We are truly indebted to you for this very, very important, very clear message that you have given to the nation and to the world, that the fourth administration will be committed to protecting the independence of the judiciary. Once again, I would like us to give the President a round of applause for that important statement. Your Excellency, you mentioned to all those who cared to listen that you intend to serve only the unexpired term of your predecessor, but I must warn you already that there may be the last legal year that you will have to come and address us before that happens. So we look forward to receiving you again next year. Thank you, Your Excellency. I would now like to invite Her Worship, Ms. Ingrid Unengu, the Acting Chief Magistrate, to give the vote of thanks on behalf of all of us, after which we will then have the
A cardinal feature of a constitutional democracy is an independent organ of the state that advances justice through the rule of law and a system that provides fair, efficient, effective, and accessible justice for all. It is a feature founded on the doctrine of separation of powers, the principle that requires that the three organs of the state, the executive, legislature, and judiciary, exercise their constitutional functions independently from each other. The Judiciary of Namibia is established under Article 78 of the Namibian Constitution. Article 78(1) of the Constitution vests judicial power in the courts, the Supreme, High, and Lower Courts of Namibia. The courts execute their constitutional mandate independently and only subject to the Constitution and the law. The amendment of the Namibian Constitution in 2014 introduced significant changes to the judiciary and its governance, according it administrative and financial autonomy. This amendment prompted the enactment of the Judiciary Act 11 of 2015 by Parliament, which culminated in the establishment of the Office of the Judiciary. The inception of this office marked a significant milestone in fortifying the doctrine of the separation of powers and the independence of the judiciary. At the helm of this formidable institution is the Chief Justice of the Republic of Namibia, His Lordship Peter Shivute. The Chief Justice is ably supported by an accounting officer who leads the administrative division of the judiciary, supported by a team of dedicated staff members appointed from the public service. The judicial structure in Namibia, outlined in Article 78 of the Constitution, comprises the Supreme Court, High Court, and lower courts, magistrate courts. At the pinnacle of this hierarchy is the Supreme Court, functioning both as the constitutional court and the final court of appeal. It is presided over by the Chief Justice, the Deputy Chief Justice, and the Justices of the Supreme Court. The Apex Court provides leadership in a way that improves on the delivery of justice by ensuring speedy finalization of cases that come before it. The High Court of Namibia consists of two divisions, the main division in Windhoek and the Northern Local Division in Oshakati. The High Court is a superior court of record and original and appellate jurisdiction over civil, and criminal prosecutions. The Judge President heads the High Court, assisted by the Deputy Judge President and additional judges of the court. The lower courts comprise of magistrates' courts in different regions, classified into regional, district, sub-district divisions, and periodical courts across the country. The magistrates' courts are courts of record, and their proceedings in both criminal and civil matters are carried out in open court. Magistrates preside over all matters brought before the magistrate courts. The Office of the Judiciary aims to ensure access to justice through efficient and effective service delivery. Access to the courts remains paramount to the institution, and equally vital is preserving citizens' trust and confidence in the judicial system. Our judicial officers, having taken an oath, defend and uphold the Constitution of the Republic of Namibia as the supreme law, and will fearlessly administer justice to all persons without favor or prejudice, and per the laws of the Republic of Namibia. They have pledged to administer justice independently and impartially. Every organization has a set of values that are essential to both the organization and the individuals that operate within its setting. The values play a vital role in assisting the organization to execute its core mandate. They also assist individuals within it to comprehend their duties and obligations. Our mission and vision is to be a world-class leader in judicial excellence. The attainment of these underpinning values largely depend on the dedication and diligence of judicial officers and its staff members at every level. From dawn until dusk, across the length and breadth of Namibia, the sound of the gavel resonates, setting the course of justice. This year, the wheels of justice continue to turn in Namibia to administer justice, reaching every corner of the nation and serving all individuals equally, without fear, favor, or prejudice. Judicial excellence, my reality.
Well, welcome back, and in case you just joined us, this is the proceedings happening live from the Supreme Court of Namibia, where we just witnessed the official opening of the judicial year. Now, back in this, with me is Mr. Norman Shombe and Ms. Shahikika. Well, we've heard the speech from the Chief Justice, as well as the keynote address by His Excellency the President, Nangolo Mbumba. What stood out for you? Especially, let's start with the speech by the Chief Justice. What stood out for you?
I think what stood out for me was there has been excellent performance by the superior courts, that's the High Court and the Supreme Court, in finalizing cases, making sure that the smooth conduct of cases are performed in these courts. And regrettably, the lower courts, the magistracy, has been far below standard. Even in the Supreme Court and High Court, we had over 70% performance. In the lower courts, less than 30%. Now that's quite regrettable, because in the magistrates court, that's the first contact that the majority of people would have with the judiciary. That's where normally, if people are arrested, that's where they would appear. That's where people see justice being dispensed with, because it deals with the majority of cases. There's a representation of magistrates courts across the country in all major towns in Namibia. So people know the magistrates courts as the first point of entry into the judiciary. And unfortunately, that has not been performed. And as the Chief Justice has indicated, something needs to be done about that. Yeah. So those two aspects have really stood out for me, that we had, I think, very good performance in the Supreme Court and the High Court, and that was great. And very, very poor performance in the magistrates courts across the country. Yes.
But perhaps, Ms. Chaika, the implication of, we always say justice delayed is justice denied. The implication of perhaps, if we may call it, not so satisfactory performance of the lower court, in a broader term, what is the implication on the administration of justice?
Well, of course, there is a negative implication, for sure. And if I may add also, Daniel, what the Chief Justice also spoke about, he spoke about retirements within the lower courts, he spoke about resignations as well. But before I even dwell into the question that you've asked, I think it's important for me to also mention that it was crucial for the Chief Justice, as he accounts on the state of the judiciary, that he acknowledges certain challenges within the system, which is something that often at times does not happen. You know, one would want to just focus on the positive, but it's important that he acknowledges that, because by doing so also, he's saying we are not turning a blind eye to the challenges that are there. We are acknowledging them. And at the same time, we are doing something about that, and which also would require support from the other parts of the sector. You know, so this would have a negative bearing, as Norman would said, because the magistrates court, as we know them, they are the first encounter of the members of the public with the justice system. But I really want to believe that the fact that it was acknowledged, there are concerted efforts that would be made to ensure that the system is improved. For instance, he also talked about the circuit courts. And that is an aspect that is equally important to say, in as much as we have the challenges, but we are trying to ensure that there is access to justice by the people. So he mentioned those in the various regions, that the Deputy Chief Justice has gone in the various regions in the country to ensure that he opens and adjudicate on the circuit courts accordingly, yes.
Yes. Perhaps let's talk about some legislative or policy changes, if there were a mention of this, and what implications or what ramification might they hold for the judiciary's operation or for the justice system?
Again, Daniel, that's another improvement. And I'm speaking now to the amendment of the Magistrates Court to address the impact of warrants of execution on immovable property. Immovable properties have been, the issue of immovable properties has been a thorn on the flesh for the most people who are affected, that would have no access to housing. So now imagine if you have the opportunity to have a house and only for it to be execution of immovable property has. So the judiciary has, and I want to add also here, that with the support of the legal fraternity, because there was a case that was registered through the legal fraternity with the High Court to address this issue, but that eventually led to the amendment that we now have, that we can all be proud of, to try and address the negative inferences from these systems that we have. So that's an area that one can say it's one improvement that should be applauded.
Yes.
Of course, there would be some guidelines. I think the Act mentions that the Rules Board would lay out procedures in terms of now what the processes would be followed in order to ensure that there is fairness in the manner in which the new system would be dealt with.
Yes. Mr. Shombe, what do you have in your notes with regard to legislative development mentioned?
Yeah, Nelly has mentioned obviously the issue of immovable property, the primary home of people. That has been a particular concern, that for small debts people are losing their homes, and that there's certain protections built in the system to make sure that those are done all across the country, in all towns and the city here. That's a first point of contact that people have with the judiciary. If they have disputes of their rights and responsibilities or obligations, that's normally where they would be known. The average person knows a magistrate's court, and unlike the Supreme Court or the High Court, it's more known that people will know the magistrate's courts. And also in terms of access to justice. I mean, people must travel from Kongola to Windhoek to Oshakati to attend to high courts, from Oranjemund, from Noordoever to come to the high court here. So if you increase the jurisdiction of the magistrate, they would increasingly be able to deal with more cases in that level. So it makes it much, much cheaper for litigants, for ordinary members of the public to access justice instead of having to travel to Windhoek where they don't have accommodation, they have to leave their children at home, they have to take leave from work and the like. So the justice will be dispensed at their doorstep, which is ultimately just absolutely the most responsive way that the legislature have looked at to amend the law to allow for magistrates to deal with more cases than they have done previously. So that is absolutely a much more positive aspect. Of course, the other legislative policy change that we have seen is the amendment to the rules to the Judicial Service Commission to allow for public interviews of judges. So the recruitment of judges will be done in public, and we've spoken about it earlier.
Yes.
That it obviously enhances transparency and accountability, and then makes it that the public would own the process. They would be. It's not an alien process to the public. They will just hear that Mr. So-and-so has been appointed as a judge, but that is in fact that there is a process that they have observed and see why that person was appointed and why the other person was not appointed. Because ultimately, the judiciary serves the public,
Yes.
and it's in the public's name that they do this.
Thank you. Let's have regard to the president's speech. What stood out for you?
I think the commitment. Look, you know, we live in a continent where this is absolutely very important what the president has said, because it's taken for granted in Namibia and in other countries. It's just simply absent. The commitment to respect the judiciary, the commitment to make sure that if the court has ruled in a particular way, that that ruling will be supported, not just respected, but will be supported and said, you have ruled against the executive, you have ruled against the legislature. We don't like your ruling, but we will support it. That is absolutely important. Now, if you know the relationship between courts and the judiciary, the courts and the executive and legislature, all across Africa, you would appreciate the significance of that commitment that the president, 3-4 days into his presidency, has committed to. And that has been the commitment of all 3 previous presidents, that they have said we would uphold and protect the constitution, including the judiciary.
Yes.
That is absolutely very, very, very significant. And we, the legal profession, will hold the president to his word. If he steps aside, we will sue him.
Well, thank you so much. Ms. Jahigika, do you also stand by the words of your learned friend that you would undertake to sue the president? No, but what stood out for you? Briefly.
Quite a number of issues, but we support. I think as the citizens of the country, we have an obligation to support the executive as much as we support the judiciary. But what also stood out for me, it's part of some of the questions that the president actually asked indirectly to us also as legal practitioner, where he says that have we discharged our duty to the best of our abilities? And the country expects that when I have a legal practitioner, the legal practitioner will give attention to my matter. When I call the legal practitioner to inquire how far is my case, that legal practitioner will be able to respond instead of me having to now be destitute. And yet there are systems in place where we are told that you can access justice. On top of that, also for the courts to administer justice in a fair and equal manner, such that then at the end of the day, even if the judgment is not in your favor, but you will be able to appreciate that the process that led to the delivery of that judgment was done in a fair and procedural manner as the Constitution requires.
Thank you so much. In the interest of time, I think we call it a day for now, but thank you so much for making time and enriching our understanding as far as the mandate of the judiciary is concerned. Thank you so much.
Thank you for
Well, that's all the time we had for you, and for now, have a pleasant viewing for the remainder of the day. I'm Daniel Nadunya, signing out.